Hello, this is session 17 of Arbitration Boot Camp, and the topic for today is case management arbitration. I've started to circulate in after my sessions a list of all of the topics of my previous boot camps. And so you can see them on YouTube, but I thought it would be useful to have a list which will allow you to at least browse the topics that you may be interested in. After this session, you will get a list of those, an updated list of my topics and a recording of this section. If you don't know me, my name's Lisa Munro. I'm an arbitrator at Arbitration Place, a partner at Lerners, and I am the editor and a writer of Arbitration Matters, www.arbitrationmatters.com, which sends out regular cases decided by Canadian courts along with a summary and some commentary on those cases. You can check out the website whenever you like. There's some content put out regularly, but also you can receive for free a subscription in which you'll get every 2 weeks on Tuesday morning at 8 a.m. The new cases. There's 3 cases that come out every second week with the summaries and, as I say, commentary. So let's get to this webinar. The purpose of these arbitration bootcamp sessions, and my purpose from the beginning, and which I've maintained throughout, is to provide practical advice that you don't get from a textbook on a lot of arbitration issues that people have questions about. And I've heard of many viewers from arbitration bootcamp who call me, and I see them around and about, and they comment on how useful they are when they're starting out, because the information that I'm providing, and of course this is my objective, is information that I hope is unique and makes the sessions worthwhile viewing. So as usual, I'll have you out by 1 p.m. I may have you out a little earlier today because this topic is an important one, but it's a relatively short one. You do have an opportunity to ask questions. I've got my Q&A box open. Feel free to send me questions during my remarks. If I don't get to them while I'm talking, I'll get to them at the end of the session, because I do monitor the Q&A box. If you forget something, feel free to email me after the session, and I'll do my best to answer it. So let's start from the beginning. What is arbitration case management, and what is case management arbitration? This is a topic that I'm hearing about more and more, and I think it's directly linked to the case backlogs in the court, which are driving people, litigants and counsel, to consider arbitration in numbers that has not previously been the case. And when I talk about case management arbitration, I'm talking about a process in which there is a relationship between the courts and arbitration. In my previous sessions, I've talked mostly about arbitration practice, which is separate from the courts. And in this session, I'm talking about the way in which parties can choose to have them interrelate and work together in a way that will bring out the best parts of arbitration that can work alongside the court system. I've been telling viewers of this boot camp since the beginning that arbitration can offer a faster, more flexible process. And case management arbitration will provide those objectives, but it also allows parties, if they'd like to have the ultimate dispute on the merits determined by a judge in a court, they can do so and still achieve many of the benefits of arbitration. Some parties just don't want to have their dispute decided entirely by arbitration. They have a familiarity with the court system. They have confidence in appointed judges. And so here is an alternative which gives parties choices. And I think this case management arbitration process can reduce the largest frustrations that people complain about, both counsel and litigants, about the court process. And the first and biggest one is delay. We're all talking about and being frustrated by the court backlogs. But the second one is the lack of case management within a court action. And the idea of case management under the rules is not the kind of case management management which arbitration can provide. And I'm going to try to persuade you that the case management that arbitration can provide is much better. And that's simply because you have a single person who you can go to if you're a litigant or counsel to resolve the various glitches that get in the way of moving a case forward, or instituting processes that make for a smooth, fast transition from pleading or discovery stage through to getting a matter ready for trial. So what is case management arbitration? It can be used by parties who want to have their case decided by a judge, but who choose arbitration to get there more quickly, more effectively, and I say more cost efficiently. Usually this will involve the part of the arbitration in which the rules of civil procedure are used. And I've said many times in Arbitration Boot Camp that it is a much more efficient and expeditious process which does not use the rules of civil procedure. But in a case in which the parties would like to get their matter ready for trial, the rules of civil procedure make sense. And then the matter is ready for trial by the trial judge. But there's still room for some flexibility in case management arbitration, and therefore still an ability to move the case forward quickly to trial. The case management arbitration therefore involves recourse to an arbitrator whose role is to try to move the case forward, to get the case ready for trial by the court, and to essentially shepherd the case to achieve that objective. So in this session, I'm going to give practical advice on how case management can work to achieve that, so that they're running essentially parallel with the courts, and how you can make the best use of case management in that context. It will overcome the court backlog problem, and if counsel and parties are receptive to it, it will move the discovery process along more quickly. This is often the most costly part of an action in the courts, and it is often the part that gets bogged down. And the case management arbitration can address most of those issues. Many of the delays in court litigation involve backlogs of the courts, but there are some which involve parties simply having fundamental disputes about things like production and discovery. And having those issues determined quickly will help, that alone will help move a case more quickly through to trial. This case management arbitration is to be distinguished from what I've been talking about with respect to the case management that occurs within an arbitration, although the benefits are the same and they look very similar. But the purpose here, I may be emphasizing this too much, is to move quickly through the discovery process to get a case ready for trial and allow the parties essentially to set the action down for trial more quickly than they might otherwise have done, and then at least get in the queue for a trial. Now, the idea of reducing delays should be apparent by my previous arbitration boot camp sessions. But if I haven't already said this, the biggest benefit to arbitration is speed. And one of the things that often shocks counsel when I say it is that if a matter is entirely heard by arbitration, it is very common to have a complex, document-intensive case heard from beginning to end, so inception of the arbitration through to delivery of an award within 1 calendar year. Litigation in the courts simply cannot offer that. And depending upon the process and the issues, it's not uncommon to get a case dealt with in a business quarter. So you can see why parties would be very attracted to the kind of speed that arbitration can offer, even if at the end of the day, they would really like to have their dispute resolved by a court. So case management can get parties to trial for a lot more quickly, because one of the solutions to the court backlog problem is having an arbitrator deal with interlocutory or procedural motions. And that's a very common way of implementing case management arbitration. The backlogs, of course, existed pre-COVID, but are worse now. And although the courts have demonstrated a commitment to trying to reduce those backlogs, for example, by reinstituting the administrative dismissal for delay process in the rules, that's just a start, and it's going to take a long time, I think, for the courts to be able to reduce the kind of backlog that will allow for courts to deliver the same quick, efficient service that arbitration can. Right now, it's taking over a year to get major motions held in Toronto, and while other jurisdictions may not be comparable, it really emphasizes the importance of an alternative. And arbitration can also allow for parties to deal with the legitimate issues that arise in litigation that parties may now be discouraged from addressing because they don't want to stand in line. So summary judgment motions, for example, are of that kind. It can take so long to get a summary judgment date. Parties which may think that they've got a valid chance at a summary judgment motion and would like to move the action forward more quickly using that motion, find themselves in a list that's so long that summary judgment may no longer be a viable alternative. So that's a very good reason why case management arbitration can really help. So why would parties want case management? Apart from the delays, which we're talking about, overcoming those delays, another reason may be that the parties would like an arbitrator with subject matter expertise. We know that we can't necessarily get that in the courts. We've got in Toronto a commercial list, which has knowledge, expertise, sophistication in dealing with commercial matters, but we may not see the kind of expertise available just generally through the courts, product liability experience, that sort of thing. And if it's essential that parties have that, or it will help smooth the process, they can get that by their selection of arbitrator. And what that can mean is the arbitrator then can make some of the decisions that are critical to getting the case ready for trial, for example, by ensuring that the evidence that is available to the court, some of the expert reports, for example, can be dealt with in a pre-trial manner by an arbitrator with subject matter expertise who can make pre-trial decisions concerning relevance, etc., that will get the case ready for trial before a judge, identify the issues that are relevant, and essentially get a full package with a bow on it for the trial judge. How does case management arbitration really work? So as a practical matter, some counsel may think that because their party's agreement doesn't contain an arbitration clause, they cannot get a matter into arbitration, and that's not so. Arbitration will require the consent of all the parties, but that consent can be obtained at any time after the dispute has started. So I'm seeing increasingly parties coming to me who are saying, we are just at the beginning of discovery, and we just think we need to find a more effective, efficient process. And so pleadings have closed. They're now embarking upon a costly discovery process, and they think that arbitration can offer something which will speed it up again and get the case ready for trial. So if the parties want to do that, it's of course important to have an arbitration agreement. And so some of the same considerations that I talked about in one of my early sessions, arbitration boot camp sessions, on what an effective arbitration agreement will provide come into play here. And so all of the issues that the parties would like to have resolved by arbitration should be included in the arbitration agreement. Or alternatively, the parties can simply decide on an issue-by-issue basis whether they would like to have an arbitrator assist them. Obviously, it's more efficient when you've got a longer term plan and you've got an arbitrator who becomes familiar with the case and understands the potential impact going forward of the decisions that are made. Parties obviously must consent, and there may be good reasons why parties would like to engage in arbitration case management. The speed may be significant because, for example, they have an ongoing relationship and the business may benefit from having a dispute resolved very quickly, which will both satisfy the parties, preserve their relationship, and possibly even preserve their business. The time and money that is spent by counsel is something we obviously talk about, but parties spend an inordinate amount of time in the trial prep process, gathering documents, being examined for discovery, instructing counsel. All of those time frames can be minimized by a case management process while they're all dealt with at the same time. If one party is opposed to case management arbitration, that of course makes it very difficult. You cannot require a party which has not consented to arbitration to agree to it. You can persuade, and one of the ways that may be effective is taking your issue to a case management judge, who again cannot order case management arbitration, but may be in a very good position to persuade by explaining to parties how long it's going to take to get motion dates, what the trial list looks like, that sort of thing. Some of the courts increasingly are starting to talk about the real benefits of arbitration and how the courts and the arbitrators can work together to try to achieve the objective that all parties have, which is to have their dispute resolved on the merits quickly in the most cost-effective manner if they can't resolve it on their own. So again, why would parties not want case management arbitration? And so if you're intrigued by the idea of implementing case management arbitration in your practice, there are a few risks that you should consider, or strategic considerations. So first of all, they are binding only on the parties, and they're binding in the same way as court orders are. However, because they involve procedural orders rather than determinations of the merits of a party's dispute, they can't be recognized and enforced by a court. So if there is concern about voluntary compliance with a procedural order, that may be a reason why you don't want case management arbitration, and that may affect the decisions that you make where there is an arbitration clause in the agreement already. This, of course, when there is a concern about non-compliance, can lead to further delays and further costs. So that issue needs to be considered. The other one is if a party needs an order that binds a third party, a non-party to the arbitration agreement, a non-party to the action usually, and that will come up sometimes when there is an order requiring production from a third party. Though that sort of a case would have to go to the court, even if the parties have agreed upon arbitration, because arbitration can only bind the parties to it. But an arbitrator can, of course, help parties work through some of those issues in designing a process. If the parties are prepared to work together, some of the issues that you can foresee arising can be dealt with. There are some variations in case management arbitration, and essentially those variations are limited only by the parties and the arbitrator's creativity and the unique circumstances of each case. So a few that I can think of. The parties can leave the litigation track at any point in the litigation, but then would want the action to be brought back to the court for the trial judge to make a decision. So many people approach an arbitrator after the pleadings stage because they see a long horizon for getting the matter for trial, and they say, and they agree, let's take all of the interlocutory matters, all the pretrial matters out of the jurisdiction of the court, put them in the hands of an arbitrator, and then we'll get back to a trial judge when we're ready to set the action down for trial. As I said, this often happens at the discovery stage, but it can happen at any time where, for example, the parties would like a bifurcation of the proceedings or an issue by issue determination. So there may be a few issues that they think can be determined by an arbitrator, and they would like the rest of them dealt with by a court for some reason. Some may be highly technical. They may be unrelated to the issues that they're asking the trial court to see, and so there may be very good reasons why some issues may be sent for trial and some issues determined by an arbitrator. The idea as well of pushing some of these issues into the hands of an arbitrator may actually increase the chances of settlement, because parties and counsel need to prepare a lot of these issues. And when an arbitrator is appointed as part of the case management process, the arbitrator will be setting schedules of dates, etc. Even by pushing and keeping the momentum of the dispute going, that often causes the parties to discuss a settlement. And where arbitration is involved, that settlement discussion may happen earlier on. Most importantly, this kind of process gets the trial record ready for the trial judge. The parties will often, in my experience, even if they want the arbitrator to serve only in the capacity as a dispute decider to get the case ready for trial, will decide partway through that process that, in fact, they have the comfort and the confidence in mediation, arbitration, that they didn't think they had at the very beginning. Perhaps they've had an experience, or their clients had an experience with arbitration that wasn't satisfactory to them, or they finally bought into the hype about what arbitration can offer. So the possibility then is for the parties to decide partway along the arbitration path that they'd like to take it all the way with the arbitrator and have the arbitrator make the final merits determination. That, of course, then will put into play an entire timetabling, procedural meeting process where the arbitrator takes the steps that have already been put in place for managing the case towards trial and extends it out to what the hearing is going to look like. Is it going to be an oral hearing? Is it going to be a hearing on the documentary record only? Are there some of the steps that have been scheduled but haven't taken place? Are they necessary because they've been timetabled in accordance with the rules of civil procedure, but maybe the rules of civil procedure don't need to be followed if the matter is ultimately going to be heard by that arbitrator? So it's never too late to decide to take the case out of the court process and put it back in litigation. There's no limitation, for example, on the ability of the parties to maintain the right of appeal if they move to arbitration, because the Arbitration Act provides a statutory right to appeal. And the award of the arbitrator can be recognized and enforced by a court in the same way that a court order made by a trial judge can be enforced. So there really are benefits and very little downside to moving a matter to an arbitrator and getting the kind of procedural protections, flexibility, time and cost efficiency, and the protections of an appeal can still be maintained. A third alternative is what I'm calling hop-on, hop-off arbitration. And that allows the parties to agree to send some, maybe all, maybe not, of the interlocutory disputes to an arbitrator. So those can include pleadings motions, Rule 21 motions, which are very frustrating for parties if there are significant delays before the pleadings even get determined. That, of course, has a domino effect on what production should look like based on what issues are relevant. So that can be sent out to get a pleadings motion decided quickly to get the parties to move on with the rest of the discovery process under the rules. Discovery plan motions. How often has it been that the parties get bogged down for months in trying to reach agreement on a discovery plan? And of course, there's time and energy and cost that goes into a discovery plan, which may or may not be worth it. There's a provision in the rules of civil procedure that provide that costs may not be recoverable on discovery motions. If there's no discovery plan, there's a cost benefit analysis that must get weighed there. But how about send that issue to an arbitrator where likely that issue can be dealt with, perhaps without any oral submissions. Probably written submissions will be sufficient and probably not that detailed. Very quick, efficient determination, conclusion of an issue that can bog down the litigation very early on. Production motions. Is this document relevant? Is it not? Undertakings and refusals motions, which are the least favorite motions for virtually every counsel and every judge and associate judge, summary judgment motions, security for costs motions, assessments of costs. Even if a court after a trial is prepared to deal with a cost issue orally, most of them are dealt with in writing. There may be a benefit to having the arbitrator deal with some of the cost issues because the arbitrator case managed the case. Motions for directions. I mean, I could go on and on and on, but you can see how these discrete kinds of motions will move a case more quickly through the courts and get it ready for trial, and may well decrease the number of games that get strategic games that parties accuse the opposing counsel of playing, often in trying to delay the action or raise issues that are not important. If an arbitrator deals with that issue, if it's dealt with quickly, you can dispense with those issues. A determination is made about whether those objections or games so-called by the other party are legitimate, and move on. The arbitrator also has the ability to award interim relief, which is under the rules of civil procedure called injunctions. So unless there's a restriction in the arbitration agreement itself, and sometimes there is, or the relevant legislation doesn't allow for it, and the Ontario Arbitration Act and the domestic arbitration acts across the country, and the model law, which covers international arbitrations, those pieces of legislation allow for interim relief. So there may be very good reasons for requesting interim or injunctive relief, one of them being that the issue can be decided in a private context and doesn't have to be open to the public in the way the court proceedings are. There's also value in the speed and the control that the arbitrator will have over ensuring the process moves through quickly. I don't hear a lot of complaints about parties in getting dates for injunctive relief, but an arbitrator can generally move more quickly, decide more quickly. But I think the real benefit is the privacy. There are some challenges, or maybe some challenges, of course, in getting parties to agree that interim relief can be found, can be done by the arbitrator. Of course, this doesn't apply to ex parte interim relief unless the parties have agreed. That would be a reason why you would have to go to court for your interim relief. So there are benefits no matter what the parties agree upon. The scheduling is easy. Flexibility in how motions are heard, and this is one of the prime benefits, in my view, of arbitration. The parties may agree to depart from the rules of civil procedure, even if they're hoping to get the case to trial. These kinds of motions are commonly heard by email, conference call. There may not even be required formal materials or evidence put before the tribunal. Notices of motion and other formal court requirements may not be necessary. And there may be very efficient ways of dealing with certain kinds of disputes, like many of you have heard of a Redfern schedule, which is a document that's very much like the Ontario Rules of Civil Procedure chart that's found for dealing with undertaking and refusals issues. It's a chart in which the party sets out the request for document production, the objection by the other party, and then reply for the party seeking the document. And then all the arbitrator does is in the final column make a decision about whether the document is to be produced or not. That is unbelievably efficient, and much of the material that gets filed with the court on these kinds of motions could probably be streamlined, and in an arbitration that's possible. So a motion that might take hours to prepare, days or months to have heard by the court, can be dealt with within 1 week, 2 weeks, that sort of thing, by an arbitrator. Those are the sorts of efficiencies that are very attractive to case management arbitration. Now I'm going to add one other variation to case management arbitration. And it's one that I talked about in the last two sessions, and that is Med-Arb. And in my last session, I interviewed a very well-respected and well-known Med-Arb mediator arbitrator called David McCutcheon. And in the session before, I talked generally about what Med-Arb is. But it is a process that's been very familiar to the family law of bar. It is becoming more and more prevalent in commercial disputes. But it allows for both mediation, usually first, and then arbitration of the disputes that weren't resolved in mediation. There's usually a very strict timetable to get a matter forward. That is, in my view, a variation of case management arbitration because a timetable is set. There are a number of stages, and there's a date for the conclusion of the dispute. What I like about it is, and what parties may like about it is they still have some control over how the dispute gets resolved because of the mediation stage. So if you'd like to know a little bit more about Med-Arb as a resolution of disputes, then check out my last two Arbitration Boot Camp sessions on YouTube. There are other tangible benefits of case management arbitration, which are not clear necessarily based on what I think are the most important issues, which are overcoming delay and making the whole process more efficient and cost effective. So, as I said, case management and interlocutory motions can be dealt with in real time, and the arbitrator will make the decision about what material is necessary after submissions from the parties, of course. But there will be a procedural order that deals with the timetable for exchanging material, what should be in that material if the parties have a dispute about that, what evidence is necessary, how much time is necessary, can this be done on a conference call? There can be consequences for the failure to abide by a timetable if there's no good reason. So the arbitrator can actually issue awards to take immediate effect for costs with cost consequences. And the arbitrator can work through some of the timetable disputes if the parties can't reach agreement. It's very common in litigation for parties to spend weeks trying to exchange information on what the motion should look like, whose motion should go first, whose motion is actually a cross motion, what evidence should be adduced, that sort of thing. And an arbitrator can cut through all of that and make a timetable relatively quickly. The other thing which I think is absolutely essential for counsel and parties to consider is that when you've got an arbitrator doing case management arbitration, you've got the time and the attention of the decision maker. We know that the arbitrator has read the material. In the courts, judges are overworked. We often hear that they got the file the morning of or the night before the motion, and they haven't had the time to read the material. And that's quite discouraging, I know. You don't have that problem with arbitrators. The arbitrator set a schedule for the exchange of material that gives the arbitrator sufficient time to read the material, and the arbitrator comes to the motion or the proceeding prepared. Another significant benefit is the fact that the amount of time that's reserved for the motion or other proceeding is the amount of time that it requires, that the parties or the arbitrator think is necessary in order to have the matter dealt with sufficiently. It is not the case that the issue will get determined in the time that the court has, which often means that parties have to squeeze in what they think is a lengthy argument into less time. And if the parties and the arbitrator determined the time that's necessary, that is a real benefit. A lot of people I've heard talk about the cost of having to pay the arbitrator as a downside, and a reason why parties feel discouraged in engaging an arbitrator for any purpose. However, consider this. There are costs in every piece of litigation caused by the delays. You've got a motion that's outstanding, or you've got examinations for discovery that are not taking place for 6 months. And each time counsel picks up the file and then has to put it down, there are costs incurred on the file and by the clients. In arbitration, that doesn't happen because the matter moves along swiftly and the arbitrator has a knowledge of the file, and the getting up to speed time is far less. The arbitrator is not necessarily considering the motion or the dispute in isolation and has the background necessary to put the particular dispute, motion, etc. in context. That creates an efficiency that the courts just simply cannot compete with. I must reemphasize speed. The issues can be dealt with by the arbitrator in real time, and there is a sense of urgency maintained, and there is no sense of inertia that can occur in litigation. And so I still think that is the greatest benefit to parties who are interested in case management arbitration. Because the parties are pushed forward without delays that we see in the court system, the chance for an early settlement is higher. We have all heard the statistics that approximately 80 or more % of cases often settle, and it's usual that those cases settle before a significant event like examinations for discovery or a motion in which the parties are going to actually have to give evidence. But very, very frequently it occurs on the courtroom doors. And by pushing and front loading a lot of the preparation in the arbitration, you are putting a greater incentive and pressure on the parties to focus on the real objectives of the litigation and can result in much earlier settlement. Parties are prepared earlier on to discuss the pros and the cons, the weaknesses and strengths of their cases, and they turn their minds to it. The early part of litigation is essentially driven by the lawyers, but in arbitration, the parties have to get involved at a much earlier point of mind. The last benefit I'm going to talk about then is the privacy and confidentiality that arbitration can offer. And this may be a relevant and important consideration at the interlocutory motion stage. A trial for many parties is the worst case scenario and may well be one of the primary drivers of settlement. And sealing orders or confidentiality orders in the courts are very difficult to get. So it's very common that, for example, when parties are looking for interim relief or injunctive relief, they would like that step to be confidential. There may be a good business reason for that, not signaling to stakeholders that there is a dispute, or there may be confidential data that needs to be, or confidential business information that will have to surface as a result of the interlocutory dispute before the courts. If there is no other reason to take part of the matter into arbitration, that may be a very significant motivator for the parties. So my next arbitration boot camp will be June 20th. I'll go back to my regular Thursday at noon, and it'll be my last boot camp until September. As I did last year, I'll take July and August off. And I think those of you who watch are probably relieved about that. The topic is going to be the role of the courts in the arbitration process. So this was a little bit of an introduction in a sense, because our case management arbitration obviously involves a court process unless the parties ultimately agree that they're going to maintain their dispute within the arbitration. The Domestic and International Arbitration Acts stipulate express circumstances in which recourse may be made to a court to assist an arbitration. So the arbitration may proceed while there are issues that are being resolved by courts. One example of that is where there is a challenge to the arbitrator. The parties' arbitration agreement may be also relevant to whether relief may be sought in the courts. So in looking at this issue, it's necessary to look at not only the arbitration agreement, but the relevant legislation. So as I've said, for example, if the legislation permits interim relief, but the parties' arbitration agreement doesn't provide for it, then that's the answer to the question. So the Arbitration Acts and the arbitration agreement work hand in hand, but there are a number of provisions in the Act, the various acts in which the court case can step in and try to either enforce, supervise an arbitration, or help the parties get over a hurdle. So that's the end of this session. It's 12:42. Thanks very much for joining me, and I look forward to seeing you at the June session, June 20th, and I'll see you then. Have a great day.